Welcome to the Board of Zoning Appeals meeting for November 17th, 2020. I'd like to first start with a roll call, starting to my right.
Don Kurtz.
Kim Keller.
Jason Cole.
Todd Chernick.
Hodge Patel.
Brenda Hamstead.
Jake Ward.
I'm pleased to share that we have a full board tonight. If you would please stand and join me for the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Item number 4 on our published agenda is approval of or amendments to our agenda this evening. I'd make a motion to approve the agenda as published.
Second.
Is there any discussion? All those in favor of approving the published agenda, say aye. Aye.
Aye.
Opposed, say nay. Motion passed unanimous. I'd also make a motion to approve our October meeting minutes as published.
Second.
Any discussion regarding the October meeting minutes? I know we had at least one member that wasn't here, so that feel free to abstain. Any discussion? All those in favor of approving the October meeting minutes as published, say aye.
Aye.
Opposed, say nay. And Jason Cole will be abstaining. Item number 6 is consideration of primary variances. Before I jump into that, we do have, this is videoed, webcast, and on Zoom. So we do have folks who potentially are joining via Zoom. If you, at the point of public comment in each of these cases, we will look for your participation. So if you'd like to make a comment during the public comment portion of a case, please raise your hand by clicking on the icon labeled Participants at the bottom of your screen, and then click the button labeled Raise Hand. That will identify to us that you're interested in speaking on a particular item. If you're calling into the meeting on a phone, you can raise your hand by pressing *9 on your keypad. And once the moderator calls your name, please unmute yourself by clicking on the microphone button on the bottom of your screen or by pressing *6 on your phone. I'll go through these again when we start public comment. The Board of Zoning Appeals is a quasi-judicial board comprised of resident volunteers of the City of Milton. The board is charged with hearing requests for variances from the standards of the zoning ordinance and appeals of administrative determination. With regard to decisions on primary variances, the board's basis for decision is provided by these 4 considerations. A, relief, if granted, would not offend the spirit or intent of the ordinance. And B, there are such extraordinary and exceptional situations or conditions pertaining to the particular piece of property that the literal or strict application of the ordinance would create an unnecessary hardship due to size, shape, or topography, or other extraordinary and exceptional situations or conditions not caused by the variance applicant. And C, relief, if granted, would not cause a substantial detriment to the public good and surrounding properties. And D, that the public safety, health, and welfare are secured and that substantial justice is done. With that, I'd like to move on to Agenda Item 6A, V20-24, 795 Colonial Lane. Would staff please present?
V20-24, 795 Colonial Lane. The requested variance is to allow addition on single-family dwelling to encroach into the rear yard setback, Section 64-416D. The site is 1.06 acre lot located on the west side of the Colonial Lane. This property is zoned AG1 and is located in rural Milton Overlay District. The final plat for this property was approved in 2001. As per section 16B and A, 60-foot front setback is approved for this lot. You can see it in Exhibit A. The property has a 50-foot rear setback along the northwest property line and 25-foot setback on the southwest property line. The lot is like a triangular shape, which is by definition of zoning ordinance only has front and sides. So the property effectively has two setbacks, front setback of 60 feet along Colonial Lane and two side setbacks 25 feet along interior property lines. The applicant is proposing an addition to the existing house that would encroach the rear setback, as can be seen in Exhibit B. The house is sitting on the highest level of lot. Moreover, the property is sloped and wooded on both sides. Therefore, the applicant is requesting a variance to encroach into the rear yard setback. Design Review Board met on November 3rd, 2020 and had following comments. DRB recommended to approve this variance. Staff response. Part 1. The relief would not offend the spirit of the ordinance because the shape of this property has caused unusual setbacks. The rear setback could be equal to side setbacks since it is technically on the side of the house and the front is curved. Part 2. Because of the topography, the trees, and the previously approved setbacks, this property owner is facing this challenge. The strict application of this ordinance would create an unnecessary hardship. Therefore, it is staff's opinion that relief shall be granted. Part 3. Relief, if granted, would not cause substantial detriment to the public good because there is sufficient buffer between the neighboring houses. Part 4. No harm to public safety, health, and safety is likely because of this encroachment into this rear setback. Staff recommendation that staff recommends the approval of this variance request as shown on the site plan.
Are there any questions for staff? I have one question. Robin, can you help clarify for this board regarding the unique shape of this lot and the triangular shape and how it's determining rear yards?
Sure. In our zoning code, triangular lots are, definition is that in triangular type lots, there's only sides and rear, and a front and two sides, I'm sorry. So like a pie shape, it would have the front of 60 in AG1 and 25 on the sides. And so in this case, this property, although the plat was approved prior to the City of Milton's incorporation, they put down some other setbacks that, in our opinion, is not the most closest to the definition or following the definition of a triangular lot.
Okay, so the plat identifies this side, appears to be a side yard, as a rear yard.
And it doesn't even really make sense, even as a rear yard. If I was going to call out one front yard, it might be the curve along the actual cul-de-sac, and then the rear would have been the south property line, and then a side, and then a side corner. But it doesn't even make sense, even if you tried to make sense out of it.
Okay, so is that clear to the rest of the board? Essentially, there's two sides. However, the way it's platted, it's shown as a rear yard, which has a different setback than a side yard? Okay. With that, if there are any additional questions for the staff before I call the applicant? Would the applicant please come forward and you would just state your name and address for the record?
Raymond Hsu, 795 Colonial Lane.
I'm Susan Chu.
Okay. Is there anything you would like to share with us regarding your application?
Nothing from what's already been discussed. I mean, ultimately, yes, our side yard has what looks like a rear yard setback. At the end of the day, we are looking to make that addition. So, but there's good boundary still. There's, even with the addition, the side yard is totally covered by greenery and trees. So, and we do have a letter from our neighbor supporting. We do.
You do. Does staff have that letter?
Yes,
support.
we do. I believe we have a letter that we included in the packet.
Is it in the packet?
It had like it was like a text, remember?
No, sir, letter.
I have another copy.
Do you have it? Okay, yeah, let me show it. Apologize.
Robin, if you would just...
It's different. This is this letter of support from 785 Colonial Lane. We own and reside at 785 Colonial Lane, Milton, Georgia, next door to the homeowners at 795, seeking a setback variance. We have been in communication with the owners, Ray and Susan Hsu, and have viewed and discussed in detail their architectural plans for modification to their home. We do not believe issuing their requested variance on the setback will negatively impact our property, nor our home values. The tree buffer planted by the Hsus years ago provides adequate privacy between our yards. This buffer will remain intact.
Okay. Thank you for reading that into the record, and thank you for securing that from your neighbor as well. Is there anything else you would care to share before I ask the board if they have any questions for you?
No.
Are there any questions for the applicant? Hodge?
Do you have any letters of support from the homeowners association?
I don't have it with me. I can find the email. It has been approved by the Homeowners Association. If you give me just a minute, I can pull up the email if you'd like. I didn't print it out.
If it's important to you.
Yeah, if you have it.
Okay.
While we're doing that, is there any reason that can't go into the record?
Yeah, we'll make a copy of
Yeah.
it.
Okay,
We can
yeah.
forward it to
Yeah.
Robin
Right.
for record.
Is that so the intent of your asking this question is to have that entered into the record?
Let's just have it in the
And the city attorney would approve?
Yeah, as long as it gets into the record. And I wanted to get the neighbor's letter as well.
Yes. Okay.
Okay, I saw them bring it back, and I just wanted
So
to...
if you could just forward that to Robin.
Will do.
Any other questions? Anyone? All right. So the way this procedure works is I'll now open this up for public comment to see if there's anyone here to speak in favor or against. And then you'll have a chance to make a closing comment at the end if you care. Before we render, we may have more questions, and then we'll go into a motion.
Okay.
All right. So if you could have a seat for a minute. Do we have any interest in public comment online?
Neither for in favor nor in against.
Okay. Are there any questions that have arisen for anyone on the board prior to us closing and working towards a motion? If the applicant, if you please, if you have any closing comments before we would weigh in, you're welcome to do so.
No comment.
No comments from the applicant. With that, are there any closing questions for staff or the applicant? I make note that the public comment is closed, and I will open the floor for a motion and a second.
I'll make a motion to approve B20-24. We need to put the notation about the HOA in the conditions. Oh, based on the site plan. dated 9/9/20. And
By TBDG.
I'm looking at two.
So the most accurate and latest would be on the top. On the
11/14.
top. So that has the, there's a site plan. It's the one that's on your top. It has the property survey with the actual addition on it.
Yeah, so 11/14.
Right, yes.
So site plan dated 11/14/2020.
By TBDG. I'll second that
By TBDG, yes.
motion, but I do have a comment for discussion, and that is the proposed elevations. So this 1114 would give us a footprint, but adding in
The elevations.
the elevations
that were submitted, yeah.
would give more adherence to what the final aesthetics are.
Yeah, no, I know. I'm just looking for the date.
And so I guess I'd like to make a friendly
9/9.
amendment to add the elevations as a condition by TBDG dated 9/9/20.
Which would be subject to the architectural review, or basically the city architect,
It
correct?
still will be, yes.
Okay, yeah, that's,
So what will happen is when they submit their building permit, we'll just compare it, the submittal of the building permit with the approved plans to make sure they're consistent. That's our approval.
So this is just an open motion. I don't have a second.
Second.
I'm sorry, who was the second? Hodge.
So my intent would be so that we're not just giving them a footprint of a variance, it's for this intended product.
got it.
So is there any discussion on that? So we'll first vote on the amendment. All those in favor of adding the friendly amendment to add the elevations as a condition by TBDG dated 9/9/20, say aye. Aye. Opposed, say nay. So that aspect of the motion passed unanimous. We'll now move to the primary motion, which was to approve with condition for site plan by TBDG dated 11/14/20 as the condition. Any further discussion on that? All those in favor of approving, say aye.
Aye.
Opposed, say nay. Motion passed unanimous. I'd ask you to continue to keep working with
Mr.
staff
Chairman?
on your project, and
Mr. Chairman,
congratulations. Yes.
I just want to be clear, when you restated the primary motion, I think you only mentioned the one condition. To be clear, there were two conditions after the amendment.
That was my intent. If I omitted that, I apologize.
Can we go ahead and redo that motion as stated with both
So the
conditions?
motion is to approve with two conditions. The first condition is according to the site plan by TBDG dated 11/14/20. The second condition is according to the condition for the elevations as provided by TBDG dated 9/9/20. All those in favor of approval with those two conditions, say aye. Aye. Opposed, say nay. Now your project has been approved. Please continue to work with staff going forward on your building permits and architectural reviews. And congratulations.
So I just want to make a general comment. I only have one more card, so any other applicants here, if you can please fill out the yellow card in preparation of when it's your turn to speak, that would be appreciated. Or anybody else who wants to speak on any of the items, please fill out a yellow card. It's over here. Yeah.
The next item on our agenda would be V20-25 14102 Seabiscuit. Would staff please present?
14102 Seabiscuit, Triple Crown Subdivision. Requested variance is to remove two conditions for a flow well and pervious pavers from variance case V 2013 that allowed pool, deck, and pool equipment within the 75-foot impervious setback with conditions. Section 2426, 1 and 2. Background: this site is a 1.29 acre lot located along the north side of Seabiscuit in Triple Crown subdivision. It is zoned Community Unit Plan CUP and is located in rural Milton overlay. The final plat for that phase in Triple Crown was recorded in 2005, which only had 25 feet state buffer. In September 2020, the pursuant to V 2013, the applicant proposed to build a pool in 75-foot impervious setback as per Exhibit A. Section 20-426(1)(2) states that an undisturbed natural vegetative buffer shall be maintained for 50 feet measured horizontally on both banks as applicable of the stream as measured from the point of rested vegetation, and an additional 25-foot impervious setback is required adjacent to a stream. Pursuant to V 2013, the pool was allowed by the BZA within 75-foot impervious setback with the following conditions. Conditions: 1, per site plan by Neptune Pools dated July 12, 2020. Place temporary construction fence barrier along the construction area no further than 10 feet into the 50-foot undisturbed buffer. This area shall be replanted. No pool, structure, wall, foundation encroachment permitted into 50-foot undisturbed buffer. Drainage plan required to include flow well to mitigate runoff. Pool deck surface to utilize pervious pavers. The applicant now wants to remove two conditions: 1, flow well, and 2, pervious pavers for the pool deck surface. Design Review Board met on November 3, 2020 and had following comments. The DRB supports the BZA's original conditions of approval pursuant to V 2013 and does not support applicant's request to remove two conditions. Staff response. Part 1. Relief, if granted, would offend the intent of the ordinance since city has been consistent with the application of impervious buffer regulations. In addition, mitigation techniques are available to reduce impervious coverage. It is the applicant's position that mitigation is unnecessary, which offends the intent of BZA's previous condition for the approval of V 2013. Part 2. There are no extraordinary and exceptional situations or conditions pertaining to this particular piece of property that the literal or strict application of the ordinance would create an unnecessary hardship due to size, shape, or topography or other extraordinary and exceptional situations or conditions not caused by the variance applicant. Part 3. Encroachment into the pervious surface without mitigation could cause a substantial detriment to public good and surrounding properties. Part 4. The public safety, health, and welfare would not be secured, and substantial justice is not done by eliminating the two conditions previously required for the construction of this pool. Staff recommendation is Staff recommends denial of variance request to remove two conditions pursuant to V 2013.
Are there any questions for staff? If there's no questions for staff, I'd ask the applicant to come forward. And please state your name and address for the record.
Brian Wobrock, 14102 Seabiscuit. So, I want to follow the rules, and I want to keep the water clean, and I want to do what's necessary. And I understand that we go by the City of Atlanta stormwater guidelines for the most part because we don't have Milton stormwater guidelines written out. I just learned that I guess Bob is going along with the City of Atlanta in not necessarily requiring the square footage of the pool to be included since it's capturing its own water. So that's great. And now we're left with 405 square feet of brick paver deck that we have to do something with. Right now, there's a flow well and pervious pavers. And pervious pavers, as I didn't know when we first met, are not friendly to pool areas as they have stones in between each of the bricks. And so as you walk over them with your wet foot, it kind of can capture the stone and then it puts it on the hard pavement and it's not a comfortable feeling. So I don't really want to have pervious pavers if I can avoid that. So I was talking with an engineer and I think we came up with a really good solution that would solve the mitigation of the water. And in place of a flow well, which is taking water off of the roof to treat because you can't capture what we were originally going to use as the water from the pool, the surface area of the pool. So instead of doing that, we could put a modified French drain, which is also part of the City of Atlanta stormwater guidelines, as a potential way for stormwater mitigation and quality. So, and what I would propose is that we put it, if this were the deck and the downhill slope to the river, I would simply put the French drain per required size and scope to cover.
Go ahead and get back to the microphone so the folks online can hear you.
So I would propose that I'd build the drain per the specifications along the front so it would catch all the runoff or sheeting that would occur off of the hard surface, and it would be able to be collected. Is that me? So if we do the French, modified French drain as described in the City of Atlanta stormwater guidelines, it would replace the flow well and capture any sheeting water so the pervious pavers wouldn't be required in that area.
So have you discussed this alternative? Have you worked with staff on this alternative?
No, I would like to actually. I tried to make one call and it's didn't have a lot of time. By the time I found the solution, it was 4 o'clock and I didn't really expect.
This is a late breaking, that's, I understand.
But the idea was to get a solution that would keep a flow well or keep the water, instead of just totally getting rid of. I'm trying to propose another qualified alternative.
So it's still your requested position to have the two conditions, which is the flow well and the pervious pavers, removed, and alternatively what you're suggesting is producing a French drain continuous to the rear of that project.
Exactly.
I don't know if so the French drain you're referring to, did the engineer do the calculations on that to determine whether or not the French drain would suffice as well as the flow well? The calculations of how much water the flow well's capturing versus how much the water the French drain
Right,
would
it's
capture.
that's all based on, you can make them any size you want. and-
Correct. So the calculations have to be done by the engineer or the civil engineer, the guy, whoever
Yes.
needs this site plan.
Yes,
So you wouldn't need our permission for that. You would just have him redesign it, bring it to, I think Ken Kagi is who does that here. He would then
Let's ask
approve it.
staff what the process.
Well, that's what I was going to ask. Are we even allowed to approve based off of his plan? If he was to have an alternative, that would be something that staff would have to approve, not us.
Turn that off for the, you're only tasked to consider variances and approve things that would not be in compliance with the ordinances as stated. So if he comes up with a solution that doesn't require a change, I mean, great, and you would not require your approval, and you wouldn't be approving any change or deviation from the zoning ordinance,
So I think I understand that, and I'd like to ask.
at least for those provisions.
Right.
So the conditions was or is to a flow well as the mitigation option. And if there's another engineering option that is available, which is suggested here, he's still bound by it being
Okay.
a flow well.
But that's what his request was on this variance, is to seek relief from your condition
Okay.
that you put on in September to
Right.
relieve him of the flow well and the pervious pavers. And he's suggesting, in lieu of those two items, to provide this French drain solution.
Right, so let's address point number one, which is, we're not really here to solution, and I appreciate that this is something that came late to you, but I would ask for the staff's position on this in terms of whether or not this is even able to be considered as an alternative from an engineering standpoint.
I have no idea what he's proposing. The city of Milton goes by state regulations, not city of Atlanta, so most detention and water quality issues are all state regulations. But either way, what he's describing would be something in lieu of the dry well or the flow well. It would be like an oversized pipe that's buried in gravel or something of the sort. So, yeah, it looks like just sort of like a buried pipe with some gravel around it that would sort of act like a flow well. Flow well is just a big tank, and he's saying he'll just do a linear pipe with gravel around it, sort of like just a different configuration. So we do have city staff that reviews the site work, and they would look at it. We've substantially reduced your volume, the quantity of volume. So I think that would help them. But there are two real things here. One was the flow well, and one was the pervious pavers.
And it'll affect the calculations depending on.
And yeah, I mean, I guess he's looking for relief on. Initially, we asked for a flow well. Then the conversation came up at that meeting saying, well, we also want pervious pavers.
Right.
So I think what the applicant's asking for is relief really from the pervious pavers, because he's just doing a substitution of the flow well with another sort of buried unit. And that would be an engineering, just like
That's what I'm saying. So we could approve this based on the condition that you had another engineering, which would be redundant, because if you had another engineering, you wouldn't need our approval. So, I mean, we could vote that we approve this based on the condition that he brings another calculation done by an engineer for another water mitigation alternative, which you wouldn't need our approval for that anyway, if you had another alternative to that water mitigation. So
if we struck, what Jason's saying is if we agreed to remove the condition on the flow well, correct me if I'm wrong, we would introduce another condition to have you bring forward an engineered study that would be equal to addressing the mitigation from the pool.
correct. So you would,
It just wouldn't specify necessarily flow well, but it would still be
Right.
require an engineered study, calculations to ensure that there's proper mitigation for any runoff created by this project.
I think flow well aside, I think a big part of this is that pervious pavers are not conducive for a pool. You're trapping water between a pool, between the concrete wall of the pool and your house. So the idea of letting water seep through the pavers is not ideal, I think is what your pool builder is telling you. I learned the same thing when I was doing research on my pool.
They're related
Right.
because if you have a solid surface, an impervious surface, then that's going to create more runoff, which is going to change the calculations that you need for collecting that runoff. So
Correct.
they're definitely related. I've asked staff, if there are other, so what the applicant suggested was in a pervious paver situation, there would be stones in between the pervious pavers. Are there other solutions? I recall seeing others as an example that would be less or more
Yes.
friendly to a pool?
Right, so in some of the other cases, there's an example of the pavers and then with grass in between, not stone, and they make a really nice look. But 3-4 inches, I mean, it would be, we have a picture in some of our other staff reports of that example of an area with pavers but with grass in between, and that we've determined that we'd give you 100% credit for that. Because basically the water's going on to the paver and then just going into the grass and absorbing into the ground, so.
Yeah, I recall, and we've had the benefit, since this is a recent case, and we've had the video of this as well. One of our concerns that resulted in these conditions is you're almost entirely, if not entirely, in the 75-foot impervious buffer with this project.
Correct.
And for a stream, and that's pretty sensitive material in the city of Milton. And as a way of mitigating that amount of impact, these are common mitigation options that this board and the city suggests.
Right, and so because you can't catch the water from the pool and the deck, the flow wells, and we're going to be collecting other water, and the water would from the decking would sheet off, right, and go down the hill. So pervious pavers would help to reduce that, and I understand that, which is why I'm proposing that we put the French drain where the water would sheet off and would catch the any water that's going toward the stream. And in addition, we can size it larger than necessary. The flow well and the pervious pavers perform the same duty, right, of mitigation of a quantity of water. And so if the question is, we want to do more than what the size of the deck is, the 405 square feet, if we don't have pervious pavers but make the French drain larger, we could accomplish the same thing that you're doing. We could make it twice the required size for the 405 square feet, so that we could still not have to deal with pervious pavers, but give you just as much water mitigation.
But that would be the civil engineer to determine that calculation. You just
Sure, I wouldn't calculate it out.
Yeah, it wouldn't be an opinion-based thing. It wouldn't be us to decide that. It just, you come in with staff and say, we're not going to do this anymore, we're going to do this. They're going to look at the engineer report and say, the engineer is essentially telling them, this will work, this is what you have to do, and they're going to prove that based on the City of Atlanta guidelines. So where they proposed this the first time and they said, okay, you're going to bring in another one that's going to be different, and they're going to, as long as an engineer stamps it or says this will work, they're going to say, okay, well, you can do that.
Okay, great.
So, I mean, Bob, am I right on that? Is there any?
No, I just didn't
We
want to
made
be constrained. Oh, I'm sorry. I thought you were.
For the flow well, I think he was making a substitution. The pervious pavers are separate issues.
Correct. And that was where I was going with that. So if you did,
More than willing to entertain an alternate solution.
Can I?
Use the size of it.
Let me make sure it's clear. If the zoning condition or the previous variance condition required a flow well, I think tonight from what I'm hearing, if the plan that you just described were to occur, we should have the zoning or the variance condition read flow well or equivalent as approved by the city engineer. Just to make sure that the condition doesn't absolutely require specifically only a flow well, that would be the change that you would adopt tonight.
I think the reason it says flow wells because that's originally what he submitted.
Whatever the reason
No, I had
was,
nothing.
if
Still a
that's
condition of the variance that we approved.
Right.
So it has
Yeah.
to be changed.
That was a condition.
Or deferred to next
then,
month
yeah.
when an engineer's.
I have a question.
Yes, Don?
Sure. So when you put in your statement somewhere about $5,000, you said something about $5,000 to put in the flow well, okay? Yet there hasn't been a calculation at all to the amount of water that you're collecting, has there?
Yes.
Okay, there has, okay. Did you calculate that outside of using the pervious or impervious, outside of using the pervious pavers or what?
No,
In other words,
it was for
your
the
cost is
full
going to change.
1350 of the 1315, I believe, square footage of total impervious that they originally did, and that's where they came up with the gallonage that they needed, and then they needed two. I think each flow well can hold 69 gallons, so they required 2 flow wells. Now we'll reduce that because the pool is not going to be included, but that would then just require 1. And if we could do a French drain, it would be whatever requirement size of a French drain, the modified French drain, that would cover
Right.
that amount of water.
Yeah, I only asking the question because if you did another solution for the other 400 square feet, is it, of
Well,
pavers?
that's included in the,
Right.
okay.
What I'm saying, though, is if that was pervious of some type, like Robin says, grass with
Right.
pavers, something like that, you'd reduce the size of your well. Have you considered that effect? Because
Well,
that's
I guess that, and correct me if I'm wrong, the way that right now we're doing the flow wells to cover the whole thing and the pervious pavers. Now, if we get rid of the pool as a requirement, which I believe Bob's already agreed to, now we're only talking about the deck. So if you do the deck and pervious pavers, is there any need for any flow well or modified French drain? Because you're already got the mitigation through the pervious pavers. So we'd really be duplicating or doing redundant. And from what I understand from Todd was that they wanted to do as much as they could, and that's why I said if I need to do twice the French drain to give more mitigation to get the same water volume as doing the surface twice, which is the pervious pavers and a one-time flow well, I'll do that just to get rid of the pervious pavers in the guess my disfavor for them.
I guess it's more of a question, I guess, for the staff then. When the engineers do the calculation, are they going to take into account his actual impervious area when they do the calculation for what size well he needs? Right. So all I'm saying is, if you take it away from the pavers and if you put the pervious pavers in, they'll calculate well is going to be smaller, I would assume. I'm just making the comment. That's I'm not trying to design it.
And if we're saying that, and we have the option to do either pervious pavers on the one, because that's the only area that's not pool.
Yeah, I'm beginning to think that when we made the comment about putting the flow well in, at least to me, it wasn't clear that which volume we were talking about. And now I understand that the engineers will calculate that. So my thought would be that we go back to something like the attorney said, where we're not specifying anything. We're saying make sure you collect all the water that you are now causing because of you have now a non-pervious situation being created. That's what I would think we really need to specify. Not a flow well, not a pavers, not anything. Just you need to collect You need to collect the amount of water and not let it go down into the stream for this amount of space. And I guess you're saying the whole project is in the 75-foot? I didn't remember that, but.
For the most part, yes. The house was built in 2005, and so the first time I came, I actually had to get a variance for the house being inside the 75-foot as well, because.
I'm basically agreeing with you.
Yeah,
Let's talk
okay.
about the amount of water you're going to collect, not how we're going to do
So
it.
Don,
Okay.
let's bring this back. We're not here to solution that, but it's important to know that, as Jason and Bob have both indicated, there's calculations that will need to take place to determine whatever mitigation is needed. The question before us is whether or not we want to continue to state that the mitigation includes a flow well, or leave it to staff and an engineer to determine the appropriate solution.
And that's the comment I just made, which I don't think
Yeah.
we even need to give any suggestion of a solution. We just need to say, you have to collect this water.
All right, so
All right, yeah.
from a staff perspective, you feel that there are other solutions, as including what is being suggested by Mr. Wolbrack, other than a flow well, that would provide the mitigation necessary for this project? Because I don't want to put a motion forward that says to leave it to an engineered study and staff approval if this isn't a viable alternative.
Can't we put, to amend that as a flow well or equivalent mitigation drainage plan, which would be approved by city staff?
Fair. Which is in line with what the city
Right.
attorney had originally suggested 20 minutes ago.
Well, that's what I was thinking all along. I mean, it didn't make sense to remove it.
Well, that's also part of our consideration, because that will drive the calculations. So they are related in that respect.
Yeah, I don't think I don't see you being able to get rid of your impervious pavers, your 400 square feet. Because you may be able to get rid of the pavers, but you're not going to be able to get rid of the impervious part. Whoever does your engineering is going to say you can do sod, you just can't pour a concrete slab there, because you can't catch that water, and all that water is going to hit that slab and then go over the hill and down to the stream. And if you're saying I can catch that water with a pipe, and the engineer says, yes, you could do that, and that would then therefore, but you're in an impervious area, and you're trying to put pervious materials. So therefore, I don't see you being able to do that.
Is it possible
I'm not wrong. I mean-
so our pool, we've got impervious pavers. We have areas that dip and catch the water in pipes and then route that water to whatever the solution maybe you've proposed might be an option. But there is ways to capture the water up with impervious pavers through dips and drains.
And that's what I'm saying. That's going to be an engineer to decide that. If he can figure it out, you don't even need our approval. You would just take it back to the engineer, back to the city engineer, and say, hey, we've redesigned it. We've figured out a way to do it where it's going to work. And it's not an opinion issue. It's a mathematical issue where they've calculated how much square footage you have versus how much water you're collecting. And they're going to say this will work or this won't work.
I'd also encourage you to work with Neptune on it. They did all of this for us with Milton, and they've done it 1,000,000 times.
All right, I think
I'd bring them to the party.
I think we've cycled on this one pretty well.
One last point.
Yes, Bob?
That the solution he has here, he's already right up against the 50. If this is then trenched, that will disturbance into the 50.
Yeah,
The other way, we were thinking a bunch of.
which we had noted about putting a temporary construction fence to mitigate there being any intrusion into that 50.
Right.
So since this project, as it's described right now, is right up against that 50, putting any mitigations, engineered solution next to that would be further intrusion into the 50, is what Bob's suggesting.
Okay, so if we can keep it out of the 50,
Then you'd be reducing the footprint of your pool.
the deck area, yes. Because that's what we're trying to catch, is anything that rolls or sheets off the deck. So if we pulled the deck in a foot, then we could put the trench with the 6-inch pipe, permeable pipe, and the gravel right in front of it. So as it sheens off the wall, it goes right into the French drain, modified French drain, and it's diffused into the
Okay,
earth.
so we're doing exactly what I warned against, which is solutioning. So I think we've heard enough and we'll have a chance for a closing comment and more questions if necessary. But let's see what the public has to say,
Okay.
if any, and we'll go from there. Okay.
You want me to sit down, or do you
I'm
want
going to ask Robin. Do we have any public comment on this one?
No, we do not.
And anyone from Zoom?
Nope.
Okay. Just a quick reminder, if you are logged in on Zoom and you wish to speak during a public comment period, but the button at the bottom of your screen labeled raise your hand will alert us that you're interested in commenting. All right, so with that, we're down to final questions, final statements. Do you have anything further to add?
No, but I understand that we're trying to do what's right for the water, and so I want to do that. But I like the idea of talking with the engineer, working with him, and having the ability that if we can find a solution, that we can eliminate both the pervious pavers and the flow well.
Okay. Are there any final questions for the applicant or for staff? You can have a seat. I do have a question for staff, which was raised here by you at the end, Bob. If there are alternatives that surface and it changes, because I believe we made this approval contingent on this site plan, and if it changes then the footprint of the site plan, is that not going to impose then a need to revisit this variance again?
If the footprint changes the site plan, the requirement would have to be amended as well to add a new site plan.
So I guess maybe what I might suggest is we would defer this case. I'm only bringing this up for discussion so that the applicant and their engineer and staff can work together to bring a full-baked package of whatever you're wishing before us versus it being piecemeal. Okay, so with that last comment, I'm going to note that the public comment is closed, and I'll open the floor for a motion.
I'll make a motion to defer number V2025 14102 Seabiscuit.
And might you add what we're looking for to happen during this deferral?
So that we can, so that the applicant can have the opportunity to meet with an engineer, meet with staff, and come up with maybe some other alternatives.
I'll second that motion. Any discussion?
Yeah, I don't necessarily disagree, but it seems to me we could accomplish the same thing by putting the wording in here that the applicant needs to meet these requirements to capture this water, go off and do it, and rely on the staff to work with him to get that done, rather than it come back to us and us solution it again. I mean, we are not the solution people, so it seems to me we could say, you need to do this, you need to capture all the water that's in the pervious area, of the impervious area, and work it out with staff. Now, if he changes the design, then that's a problem. But
I agree with you, Don, except our concern is the alternative may change the design, which is then going to require another variance because we made this original per the site plan. So if the site plan changes in order to accommodate a new engineering solution, we would rather all that be determined with staff and an engineer outside of this session so that they come forward and say, here's the alternative we have. We've engineered it with pervious pavers, with impervious pavers, and this is what it looks like.
well, either way, they'd have to come back, right?
Correct.
If we delay it, they have to come back. If they make a change to the site plan, he has to come back. I don't know. Well, I'm not necessarily in disagreement with the motion.
Okay.
Excuse me. I have a question for and I apologize. I just want to clarify, as far as advertising requirements, the motion is to defer it to the December meeting, I believe. But if he needs to amend the site plan, will we need to re-advertise? So I'm not sure that even December will give us enough time. By the time he figures out what he needs to do, it's Thanksgiving next weekend, and then we have to have 15 days, and it takes me another 7 days to be able to get it into the newspaper.
I will say, you can advertise for a variance that he doesn't wind up needing at the meeting if there's still time to get that advertisement in so we could advertise for a variance to the site plan requirement to
Oh, for
propose
the
it.
future, yeah, for
Right.
the next one. Okay. So we could go ahead and advertise
If it's anticipated.
tomorrow for the next week's publication and then go from there.
And therefore, whatever alternatives he brings forward, if it includes a site plan alteration, we could make a determination on that.
Okay.
Right.
Yes.
So
I
that's
just
fine.
wanted to
Yeah.
make sure we had a game plan for
Right.
your deferral, so if that's what gets approved.
Yeah, it would definitely need its advertisement since it has not yet been advertised, but we can anticipate that it might need to be done.
Okay. And I apologize for interrupting.
All right, I hate to do this. Technically, the public comment portion is closed, but Mr. Womack, I'm sorry if I mispronounced your name. Brian? Wolbrock, sorry.
One quick thing, if we don't change the footprint, if we put it in that we can't change the footprint, so we don't have to come back here, we either put the flow wells in the pervious pavers, or we find an alternate solution with the same footprint, so we don't have to come back. This is our second time, it'll be a third time in December, and they've been 2 months apart. I'm just looking for a way that you can approve what you need to approve, and that I won't change the footprint, which I think that what we had talked about was we go talk to the engineers with whatever requirement, and then I get that approved. I'll do that, and if we need to put a flow well in instead of a French drain, we do that. If we need to put pervious pavers in, we do that, but
All right, hang on. I made the mistake of reopening the public comment, and I shouldn't do that. So I think I think this whole board has heard your appeal, which is this is months and months. I get it. But we're still stuck, in my opinion, we're still stuck with, and we're in discussion regarding a motion. Who seconded it? I seconded it, yes. With solutioning, and although, go ahead.
I'm beating a dead horse, and so maybe I'm not getting. So I'm confused. So on page 3 are the water calculations.
You can't engage in that.
Okay, so on page 3, the water calculations were done based off of a flow well calculation. Okay,
Right,
you see-
and they were also based on including the pool as part of the
right,
surface.
which is the pool is what got the variance, being in the setback.
Right.
So if he doesn't get, if he just finds another way to collect that water, then staff, is it okay to, can I consult staff on that?
No,
What I guess I'm trying to say is if he finds another way to collect that water through an engineer, however he decides to do it, that engineer approves.
because we specified it to be a flow well as the
We have to-
solution.
We have to modify our variance.
Right. If we want to open it up to the engineer and staff determining that, then we should be less restrictive in the condition.
Well, I guess my motion was going to be so he can move on with his project under the conditions that he and the engineer and staff come to a solution that does not change the footprint. And, sir, that may be
That's what he's requesting.
don't get to make changes because there are no alternatives.
We have to come back again.
And I think that's pretty much what I said
Right.
previously. I agree.
All right. That's, is there any more discussion regarding this standing motion, which is to defer? And it may not pass, and we can revisit
I
that.
think there are too many things that are open-ended. I think, he hasn't yet met with an engineer. We can't really remove the flow well. We can amend it as to another alternative that would be approved by the city. But he's already 75 feet in, so how's that going to change, or in the 75-foot buffer, so how's that going to change the impervious? That's not going to change that. I feel like, I don't know. I mean, there is that option to amend what we had approved.
Well, the last piece that, and so we've talked extensively about the mitigation of the runoff and collection of that, but this also includes the removal of the pervious to put in impervious, and we really haven't discussed that aspect of it either. In terms of what the board's sentiment might be, although it's fully within the 75-foot impervious. I'm going to take a vote on the motion to defer and see where we land. So the motion is to defer to allow the applicant to work with staff on solutions to determine whether or not they need to come back before this board as early as December of 2020. And staff will be making the advertisement such that if there is a site plan change, we would be able to entertain that in the next hearing. All those in favor of deferring so that can take place, say aye.
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 All those opposed, say nay.
Nay. Nay.
Okay, so the motion to defer passed, which means the applicant would have time to work with an engineer and staff on a solution prior to the next meeting.
Did staff get the opposed and in favor?
Opposition was Mr. Cole and Mr. Kurt.
I think Mr. Ward was
Sorry, I thought it
opposed as well.
I oppose.
Oh, and Mr. Ward,
Okay, so it was 4-3.
4-3. Okay, the next item on our agenda is V20-26, 660 Glendalough Court. Would staff please present?
V2026 660 Glendale Court. Requested variance is to allow addition of an accessory structure to encroach into side yard setback. Section 64-416I. The site is a 1.745 acre lot located on the west side of the Glendale Court in Enniskerry subdivision. This property is zoned AG1 and is located in rural Milton Overlay District. The final plat for the property is approved in 1992. As per section 64-416C1, a 25-foot setback is shown for this lot. On the north side of the subject is a piece of land that serves as a road frontage for a house that is located across the lake, which is not being used by owner. The applicant wants to build an accessory structure on the property that would be used as a garage, Exhibit A. The existing driveway would be used to access the new two-car garage. However, the structure is encroaching into north setback by 10 feet. Therefore, the applicant is requesting a variance. On November 3rd, 2020, the DRB met and had following comments. Recommends approving the variance, requesting that applicant provide a support letter from property owner at 655 Glendale Court, provide a floor plan and elevation of proposed structure. Staff response, Part 1. Since there is an additional 20 feet wide strip of land available between the two neighbors, the side yard encroachment, if allowed, would not offend the spirit of the ordinance. Part 2. Because of the location of existing driveway, the shape of this property, and the lake to the rear creates an unnecessary hardship due to size, shape, or topography of or an extraordinary and exceptional situation that would support the proposed location of the accessory structure into side yard setback. Part 3. Relief, if granted, would not cause a substantial detriment to the public good because there would be 35 feet between the structure and adjacent house located on the cul-de-sac. Part 4. Public safety, health and safety is secure because the new structure would be at the safe distance from the existing house. Therefore, staff recommends approval of this variance request for single-story accessory structure.
Are there any questions for staff? Go ahead, Hodge.
Do we have any letters from the adjacent property owner?
We have one. Not the one that DRB requested, it's different one.
Well, this is in opposition, but the request from the BZA, we do not have that property address support letter. In fact, I believe that they're in opposition to it, or that they've indicated that they...
I recall that we received correspondence today in opposition.
That is 660 Glendale Court.
Right, which, can you state the names of the applicants? I believe it's on the plat here as well. Or the names of the neighbors in opposition, is it Conina?
And we also have 645 Glendale, they're here in person in opposition.
Okay. So there's a 20-foot strip, which is technically the adjacent. However, it's a...
It's 35 feet. Oh, the 25, okay.
And then there's lot 35, which is the physical, where there's a home. They're in opposition. And you can see that on the site plan. We do have drawings and elevation as well that was requested by the DRB. Has staff had a chance to review these elevations?
We've received them. They look appropriate for the rest of the house. And technically, we don't have any oversight on interior lots in a subdivision, but it looks appropriate with the existing structure.
It's a two-car garage with an attic above, although it looks like a second story. It's actually attic space, not to be, and we can clarify this with the applicant. But, and so I'll wait for the applicant to clarify, because I also see some notes about a washer and a dryer, et cetera. Any other questions for staff?
Yes.
Yes, Don.
In the attorney's letter for the neighbors that are opposed to this, they state that they don't believe that this was advertised appropriately. At the bottom of the first page of the letter, they say they don't believe there was a 20 days notice and don't believe the sign was posted in accordance with 641942. And they're asking that I guess they're asking the staff here to verify. It says, please verify and provide proof of the date the sign was posted so that we can determine if it complied with 641942.
I get the count.
I just think we're going to have to answer.
Right, we're going to get the file, and
Okay.
we can
come back to it.
Yes.
Yeah, okay.
In addition to that, it states that in the second paragraph, it states that the requested or the announced variance request measurement was off.
Well, I think that the letter that was given to the neighbors, the applicant did not have that exactly correct, but the advertising was to reduce the side yard setback. So we purposely don't put a measurement in it, but I believe I looked at the letter that was sent out, and that that wasn't quite accurate, but that's not the legal notification.
I have a question. Is the existing house has the one-car garage, or they have a two-car garage, and they're taking part of that garage and making it
I think we can
Else?
ask that of the applicant when they come forward.
Okay, that's not for staff.
That was a question I had as well.
Okay, I thought maybe I just wasn't understanding.
Okay, any additional questions for staff? If not, then if the applicant would please come forward and state your name and address for the record. Good evening.
Hello, I'm Stuart Estes Barker Jr. I go by my middle name Estes.
Okay.
And my wife Jennifer. And we brought the contractor Jeff.
Okay, if you would just please state your address, and then I'll ask the contractor as well.
660 Glendalough Court.
And your name, if you could speak at the microphone, and address, please.
My address?
Your name and your business address.
Jeff Durham, 206 Tellico Road, Canton.
Canton. Thank you. Okay, so you've heard a few of our questions. What can you share about your project for us?
So the unique piece of property that is in between us, if it were split between us and our neighbors, we wouldn't even have a variance. That strip of land was put there so that they had road frontage. They live on the other side of the lake.
Understood.
Okay. Really, all we're looking to do is build a two-car garage, like many other houses in the neighborhood. The current garage would expand or not expand, but we would expand where our the laundry room, and then ultimately the rest of the space will be an in-law suite. Both her mom and my mom have dementia. They're going to be living
The rest
with
of which space? The accessory structure addition?
No,
the existing.
The existing.
Home and garage.
Right.
Correct.
Okay.
So you're taking one car garage and making it
Well, it's like
We're
a
taking
one and a half.
two-car garage and making it just a one, and then adding another two-car
Right,
garage.
you're
a
taking
detached.
one of those slots that was for
Right.
a car
Right.
and turning it into something else.
Yeah.
Okay, so just for the focus of what we're here to determine, what you do with the existing house in terms of the inside is
Doesn't matter.
is up to you.
Yep.
But we do get sensitive with accessory structures and how those are being intended to use. So let's talk exclusively about that accessory structure and what its intended use is. Two-car garage.
Two-car garage underneath a place for a lawnmower. Storage.
Okay, so no living quarters of any sort.
No living
quarters.
No
And
apartment. No
It does not appear from the elevations, the exterior elevations, that you're looking at having this attached to the home in any way with a breezeway or anything? A detached two-car garage
It's detached.
Detached.
with general architecture to match the existing home.
Correct.
Surfaces and color to match the existing home.
Correct.
Correct.
Do you have any issues with those being conditions? Meaning the accessory structure shall have material and design material to match the existing home.
Correct.
That's what we were planning on.
Yeah.
Well, I understand. Wanted to make sure that was the case.
Mr. Chairman, we checked the notice. We have a affidavit for posting the sign, and it does appear that that Mr. Hendricks said that it was posted on the 30th day of October, and that so that's only 18 days instead of 20 from today. So legally, it was not posted in sufficient time for the 20-day requirement.
Okay. That does affect our ability to hear this case. Would the city attorney please comment on that?
Yeah, we would need to, in order to comply with and have a proper hearing that would meet the requirements of the city's code, we would need to have that time frame satisfied. If we can't do it tonight, we'd have to do it the next meeting.
Okay. So unfortunately, as you heard, proper notice was not given in order for this to be an official hearing for this case. So it's best that we don't pursue further dialogue on this because we're not in a position to render any sort of decisions.
Can we at least hear the objection? The neighbors wouldn't respond to us, so wanted to kind of know what that is.
What's the city attorney's?
I would say I would welcome to do it outside of.
Yeah, I would recommend you get with staff who's in receipt of those objections, and to provide those to you.
Because we can't conduct a proper hearing, it can't be part of the official record.
So any opposition that staff has received, you're free to ask staff for that to prepare yourself for the next hearing date, which would be in December.
Thank you very much.
And what date is that, do we know?
It's the third Tuesday of December, so that would be the 15th.
Is that automatically set, or is there anything additional that needs to happen?
In terms of procedurally, I would recommend you contact Robin tomorrow morning to make sure that all the T's are crossed and I's are dotted.
And the new sign go.
And a new posting, advertisements, a new sign will go up on your property. And in this case, I'd make sure that stays there.
We didn't take it down.
Well, sometimes
No.
if it does come down, let staff know.
We absolutely did not. I mean, we saw it when it was posted.
If you see it disappearing, let staff know.
Okay, we will.
Okay, I apologize that we didn't meet our own standards of advertising. So, for the record, V20-26 was not heard tonight and will be re-advertised for the December meeting. That takes us to case V20-27, 770 Cooper Sandy Cove. Would
Mr. Chairman.
staff please present?
Mr. Chairman?
Yes.
Just one second. Let me just check the rules, whether we administratively defer that or if you need to vote.
Do we need to make a motion?
I'm just checking with the new bylaws. Because the staff does have since we're here, I would, if you just made a motion to defer to allow for proper advertisement notice.
So I'll make a motion to defer case V20-26 to allow for proper advertising to take place and this case to be heard at the next scheduled BZA.
Second.
Any discussion? All those in favor of deferral say aye. Aye. Opposed, say nay. That passed unanimous. Thank you. If staff, please present 770 Cooper Sandy Cove, case V20-27.
V2027, 770 Cooper Sandy Cove. Requested variance is to allow the lot coverage for AG1 zone property that fronts public street to go from 20% to 25%. Section 641141D1B. The site is a 1.02 acre lot located on the north side of Cooper Sandy Cove. This property is zoned AG1 and is located in rural Milton Overlay District. The final plat for the property was approved in 1997. As per section 641141D1B, lot coverage for each individual lot zoned AG1 shall not exceed 20% for lot that fronts public street. The current impervious coverage on the lot is 21%. Exhibit A. The applicant is requesting to build a pool and a deck in the rear yard that would increase impervious coverage from 21% to 24.7%. Exhibit A. The applicant worked with the city staff to reduce the proposed footprint as requested by the DRB. The revision is shown in Exhibit B. Lot coverage is defined in the zoning ordinance as the following. Lot coverage means the percentage of impervious surface located on the lot in comparison to the total lot area. calculated by dividing impervious surface area by the total area. For purpose of calculating lot coverage, impervious surface shall include the following. 1. Footprint of the main house, regardless of the size. The total footprints of any accessory buildings larger than 150 square feet, swimming pools, hot tubs, and accessory decks, and 4. Parking pads and driveways. On November 3rd, the DRB met and had following comments. Work with the city staff to reduce the impervious lot coverage. Staff response. Part 1. The home built in this subdivision have larger footprints and spacious driveways. The intent of the ordinance that came into effect in 2017 is to limit the impervious coverage or lot coverage. Since the existing lot coverage is already beyond the limit, 21%, the owner cannot add a pool without a variance. It would offend the spirit of the ordinance if applicant adds 3.71% of impervious area to the site. Proposed addition is more than 4% to existing 20%. Part 2. Although the property owner worked with the city staff to reduce the footprint of the proposed addition after the DRB's comments, the staff does not see any unnecessary hardship arising due to size, shape, or topography, or any other extraordinary and exceptional situations or conditions not caused by the variance applicant. Part 3. The increase of lot coverage could cause a detriment to the surrounding properties. This ordinance is intended for the public good, so honest efforts should be made to reduce the overall impervious coverage to this property by other means, such as using pervious material wherever possible. Part 4. Public safety, health, and welfare are not secured, and substantial justice is not done based on the amount of impervious surface, that is, the lot coverage, that is proposed with the addition of pool and associated surface. Therefore, staff recommends denial of the variance. If the BZA approves the variance, the staff recommends following conditions: use of pervious surface on the deck, on the pool, deck, and or driveway. Reduce the amount of pool, deck, or driveways.
Are there any questions for staff? I have one question, and it's noted on the, yes. Have been advertised? Yes, I will.
If we could just have, she's coming, so if we could just take a moment.
Also, it's the 30th, it's the same thing. We have to defer this one as, let me check, 7, and then last one, 28.
Can we go back and check 24?
That's what I'm going to do. Yeah, it's the 30th day of October.
All right, so staff will need to, I guess, can you advise what staff should do with that case?
For the one that was adopted, we need to contact them and let them know that, the situation, and provide them with, not provide them any legal advice, but advise them of the concerns with respect to the validity. We can talk about that after the fact, but we will need to reach out to them and let them know.
Okay, so as it relates to V20-27, we are unable to hear this case as well because it's not met the legal requirements for advertising.
That's correct. If it was advertised on, or the sign went up on the 20th, or the 30th.
Okay.
Correct.
All right. I'll make a motion to defer this case, as we have with the others. V20-27, defer to our next scheduled BZA to allow sufficient time to meet our legal requirements for advertising.
Second.
Any discussion? All those in favor of deferring to our next scheduled meeting, say aye. Aye.
Aye.
Opposed, say nay. Motion to defer has passed unanimous. I apologize to the applicants here it's no fault of your own that we are unable to hear this case tonight. There has been a change in staff, and it appears that we have missed a deadline, which is very critical for this to be legally binding. And so I will also make a motion regarding V20-28 to defer to the next scheduled BZA meeting to allow ample time for public advertising. Is there any? Do I have a second? Jason, second. Thank you. Any discussion? All those in favor of deferring V28-28 to the next scheduled meeting, say aye. 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 Opposed, say nay. Motion passed unanimous. By chance, has 29 and 30, have they been advertised properly?
The applicant had requested withdrawal. I'm assuming I have to go pull it. I just didn't pull those cases. So.
You would not need to, you could...
we could take action on those?
You could contemplate a motion to withdraw.
Okay.
I'll have that email from the applicant for both those cases.
Yes.
Packet.
Yes. Okay. Do we have to? How should we handle that in terms of motion? Do we need to
because there won't be a straight up motion is fine because there won't be a public hearing. That's what the advertisement would be directly advertising. So without the hearing, it's not an imposition.
Move right to a motion, just as I have with deferrals.
Correct.
Okay. Or someone can move to that motion. I'll make a motion to accept the applicant's withdrawal on V20-29.
Second.
Is there any discussion? All those in favor to accept the withdrawal request for V20-29 say aye. 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 Opposed, say nay. All right, that motion to withdraw has been accepted and passed unanimous. I'll do the same for V20-30 to make a motion to accept the applicant's request to withdraw. Before I, Mr. Fricke?
Yes, sir.
Is it necessary for me to make these motions without prejudice? Does that affect the applicant's ability to reapply in any way with a straight withdrawal?
It would, if you wish to alleviate them from their time restrictions, that's what the impact of the without prejudice is.
Okay, so I think I would like, if it,
motion to reconsider the prior.
Yeah, I'd like to make a motion to reconsider V20-29. But before I do that, what I'm suggesting is, if, and the city attorney can help me here, if we make a motion to withdraw without prejudice, then this applicant could come forward with another variance request within the next year. If we don't do that, the applicant would not be able to come forward with another variance request. Okay?
So do you need to redo?
I'm going to make a motion to reconsider V20-29.
I'll second.
And that would be to change that motion. So I'll make a motion to...
Let's vote on the motion to reconsider.
Oh, I'm sorry. The motion to reconsider has been seconded. Is there any discussion? All those in favor of the motion to reconsider, say aye.
Aye.
Opposed, say nay. I would now reconsider case V20-29 and make a motion to accept the applicant's withdrawal without prejudice.
Second.
Second. Is there any discussion? All those in favor of accepting the applicant's withdrawal without prejudice for V20-29, say aye. Aye. Opposed, say nay. That motion passed unanimous. For V20-30, I'd also make a motion to accept the applicant's request to withdraw without prejudice.
Second.
Seconded. Any discussion? All those in favor of accepting the withdrawal without prejudice for V20-30, say aye.
Aye.
Aye. Opposed, say nay. That motion passed unanimous. In terms of V20-24, do I need to make a motion to reconsider that case?
2-4?
2-4.
Since the public hearing's been closed and they've left,
Although we still potentially have public with Zoom.
I'm just thinking, if there was nobody here for a public hearing, does it?
well, theoretically, someone the first 2 days didn't get
They
their
could
full
argue
notice.
that.
They theoretically might have shown up. What I'd like to do is we will contact them.
So not make a motion, leave it as it stands?
You know what? I hate to do it with them not here. Let's contact them. We'll bring it up back onto. We'll re-advertise it, bring it back up on, and explain the situation. Theoretically, they could proceed, but I mean, if they're building something, we'll let them know that it's an issue. So, I mean, it'll be here next month.
Okay.
No.
So no action is required from our board at this point. Okay. It's been a long while since we've had this issue. I think your mic's not on.
What we'll do is we'll put the work permit application, if they do come in with one, on hold until they come back.
Okay.
That they don't start, just in case.
Okay. Thank you, Mr. Buscemi. The next item on our agenda is item 7, consideration of appeals and secondary variances. Are there any? Robin, are there any appeals or secondary variances?
No, there are not.
Item number 8 is old business. I'll bring this up. We're in transition with new staff supporting this board, that being Robin and Shuba. As part of that communications, we want to make sure that we're clear in getting city emails as our primary form of communications. It is I've been asked by the city manager as well, it is an open records liability for the city and for us individually. Anything that goes to our personal emails is subject to open records, and I don't think any of us really care for that. So if you're having any problems accessing or getting your city email set up, Robin has offered to broker whatever support with IT to help that happen.
Thank you, Robin. I still need support.
Okay. So if anybody could just send either me or Shuba an email or copy both of us, and we'll work with IT to try to resolve your problems.
Okay. Is there any other old business? Any new business? We do have one consideration regarding our meeting schedule.
Correct. We've provided you a draft meeting schedule for next year, so I know it's in the bylaws that you're not to approve it till December, but we just want it in front of you as well as for our uses for new incoming applicants. So just let us know if there's any issues with any dates. We did the normal moving the April date into the middle of April because of spring break, but other than that, it's pretty consistent, the first Tuesday the month at 6 p.m.
So just for the record, though, The BZA date in April, which
I'm
would be the
sorry.
third Tuesday, doesn't
I'm
change.
sorry,
It's the
you're right, I'm.
But DRB does, so you
Yes,
support
I'm
both
sorry.
boards.
Just pretend you're the DRB, and I'm saying the wrong thing, I apologize.
For our purposes, it's
Yeah,
the
you
third
got, you're
Tuesday.
pretty clean, so.
Okay. So procedurally, we clarified this. I asked that staff publish this so that you can all look at your own calendars and be prepared to hear a motion for adoption of this calendar in next month's hearing. Is there any other new business?
I've got a question that goes back to the advertising that we did on the case.
I'm not sure your mic's on. Yes, it is.
So the cases that we advertised was related to the BZA meeting. Is there any impact or is there any notice that has to be given for the DRB piece of that? And were those deadlines met? Is that something that,
So.
I don't want them to come back and we find out, oh, there was something else that wasn't advertised properly.
Let me just check about the DRB for scheduling. I know for my rezonings, I'm required to advertise for the DRB, but let me check for the BZA, just double, triple check. For the DRB, there's no official notice. It's just, as Bob said, was the 24-hour. But I know in my zoning, it does include the DRB in that advertising, which is extra, but not for the variances or for the actual DRB.
Right. And if this board defers something, it doesn't go back to DRB. It would just be deferred till the next month. It doesn't flow through the DRB cycle again.
So in terms of our meeting agenda for next month, December, it would be these cases that were not heard tonight that were deferred, as well as
The new cases, I
Which
believe
is-
we have 3 or 4, yeah. Mhm.
3.
And have all of those,
The advertisements should be going out shortly.
Yeah, this week, yeah.
that will meet the requirements.
Okay, so December is going to be busy.
Can we schedule a break in that? agenda?
In terms of the published agenda, the request was to put in a break in the agenda
Okay,
in between, let's say do 4 cases and then have to have a 15-minute break, and so that we can just adopt that.
okay,
Does that make sense?
yep.
Okay. Versus motion and amending and all that. Good suggestion. Anything else? Item number 9 on our agenda is adjournment, and I make a motion to adjourn the November 17th, 2020 BZA.
Second.
Any discussion? All those in favor of adjourning, say aye.
Aye.
Aye. Opposed, say nay. We are adjourned. Please just leave all of your